All right, good morning, everybody. Today we're going to do a couple things, starting our AP review. Um, Big thing for today is you need to go out to the College Board's site. You should be getting an email link today from the College Board with your link to the practice test, which is available today only. You need to click on that link. This will be the exact same setup you'll see when you get your actual AP test, which is 1 week from today. Um, Click on that link, go out to the AP site, and play with it the way you would take the actual test. So open up a Google Docs file, type some things in there, copy and paste it over, make sure you know how to submit. If you're someone who's planning to handwrite things, take a picture of something that you've handwritten, upload it to the site, make sure that you can do that correctly. Your assignment that I'm expecting from you today is I want everybody to please take a picture of the site that they are out there, that they're out on the site taking the practice test. Take a picture of it, either screenshot it, take a picture of your phone, do something, email me that picture. Now it needs to be a picture of you actually out there on the site, not a picture of the email or a picture of just the generic AP Classroom site or anything like that. It needs to be you out there with the actual site. I know what it looks like because I've seen the thing that they've shown for teachers. So I need a picture of that sent to me today just to verify that you have done that. That'll be a completion grade for today. Hey, tomorrow we will start going very specifically unit by unit with reviews. I'm going to do a couple things today. I'm going to walk through the Supreme Court cases. As I said the other day, they've taken out the question where we know you have to write about one of the Supreme Court cases, but the Supreme Court cases could be the second piece of information you use for your argumentative essay, or the cases could be the second extended response, which we don't know what that's going to be. We know it's going to be some sort of stimulus. It could be a chart or a graph. It could ask you to link something. Hypothetically, it could be something like where they show you some states that have been gerrymandered. They ask you about gerrymandering, then they ask you about the cases that have to deal with gerrymandering. So Baker v. Carr, Shaw v. Reno. So I'm going to walk through the cases today just as a point of review. I'm also going to show you a couple things that you all need to be doing to help yourself prepare for the test. So before I start with the cases, I want to just draw everybody's attention out to my website. Okay, you've been out here a million times. So if you go out, okay, Social Studies webpage, click on AP Government, go out to my website. Up at the very top left, there's a thing that says AP Review Assignments. And one of the things on here says Foundational Documents Summary. And this is something that you may want to print out and have sitting next to you when you take the AP test, because in your argumentative essay you're going to be asked to talk about and make your argument based upon the foundational documents. Now what I've done is I've gone through and I've summarized those for you in a few bullets. Now I want to stress this, and I cannot stress this enough: do not, under any circumstance, copy these things that I have listed here word for word, because if you do and somebody else does, they're going to get you for plagiarism. Okay, so make sure that if you're using this document just as a refresher, if you can't remember what the documents are about, please make sure that you're putting things into your own words. I cannot stress that enough. Okay, they are really going after that, but this is out there to help you. So here is your foundational documents review. You can get that out on my website. Just go into the top left-hand corner, AP Review Assignments. That is up there. Okay, I'm going to go through the cases here in a second. Another thing I want to draw your attention to: if you just go out and you type in AP Government, okay, it'll take you out to the main AP Government and Politics course page. Right in the middle of the page, it says updated course and exam description. Okay, and there's a link here that takes you out to this massive 180-some page document. Now, you do not have to read the 180-page document. Okay. What we're going to do over the next 3 days, I'm going to start walking through part of this. But if you scroll down this document, your test this year has been shortened to only units 1, 2, and 3. Okay, so if you go to the table of contents that they have here, it's got under unit guides, unit 1, unit 2, unit 3, and it's got summaries over each of those units. So if you click on one of those, it's set up to go to that section, and it will walk you through individually what each one of those units covers. So unit 1, types of democracies. It's going to talk about Articles of Confederation, ratification of the Constitution, and basically federalism, so relationship between the states and federal government. So everything in tab 1 of your binder, okay, is fair game for Unit 1. So obviously you can look back through your binder for Unit 1. You should have your Cornell notes, if you took those seriously, that are out there that have summarized the main points and definitions for those chapters. And then in this document, it will go through everything that you need to make sure. It says essential knowledge, things that you need to make sure that you can know for these 3 units. Now, because they've basically cut your test down to about 60% of the content, I strongly recommend that you read through these documents. Okay, I was very, very, very disappointed in your class last week. I went out to the YouTube site on Sunday, yesterday, and I clicked on how many people actually watched the video last week, which went over the extent of the test, and it was a whopping 11 people out of the 56 who said they're taking the test. So thank you to the 11 people who did what you were supposed to do, but everybody else is just setting themselves up for failure, because this is something that if you're not taking the reviews for this seriously, you're going to be in big trouble on this test. I do want to stress this, and I've said this before, the College Board has entrusted teachers as the first line of defense against cheating. They are going to send me your tests after you've taken this. So if I see work that I know is not of the caliber of work that you have done for me all year, I will be making a note of that to the College Board. They are asking us to do that. So this needs to be work that you are prepared for, and this needs to be something that you're taking seriously, because I am right now, for a lot of people, I'm not seeing it. Now, I want to say this, I want to stress this. Chances are the people who didn't watch the video last weekend aren't watching this video either. So, or last week aren't watching this video either. So thank you to those of you who are doing what you're supposed to be doing, because you're setting yourself up for success here. Okay, so what I'm going to do today is I'm going to walk through the cases. Okay, I'm going to come back. I'll give you guys the chance to kind of flip through this document at your own leisure. We will go through this in a little bit more detail the next couple days. Now, these are the 15 cases. Okay, it's a site out here called streetlaw.org. If you just go out to Google, type in AP Government Cases, Street Law, it'll take you out to the site. They've done a really good job of summarizing, okay, kind of like I did for the thing back there, okay. It's now free. Used to cost money. Now it's free. Okay, they've got a nice little summary here for all of the cases, but they've also gone through each individual case, and they've given you a summary here, okay, that you can click on and get the downloadable document for each case. So these are things that are out there. They're free. They're of no cost to you. Okay, strongly recommend, if you don't remember these cases, that you go out there and you look these up. Okay, so Marbury versus Madison, 1803. Big thing about this case is it gave us judicial review. So this is the case that established judicial review in the United States. Had to deal with the midnight judges, which John Adams tried to appoint on his last day in office. Thomas Jefferson refused to deliver the commissions for those judges. The lawsuit was filed against Madison, James Madison, who was Jefferson's Secretary of State, who refused to deliver those commissions. And this kind of established what the courts have the right to do. Do they have the right to review congressional decisions? Do they have the right to force the executive branch to do something? Now, if you remember when we talked about this case, John Marshall, who was the Chief Justice, was the one who was supposed to have originally delivered those commissions. He very much believed that they should have delivered those decisions, but he also said that there's nothing in the Constitution that gives me the right to force them to do that. So if you remember, there was a piece of legislation that Congress passed called the Judiciary Act, which the court struck down as unconstitutional, basically saying that the courts don't have the ability to force other branches to do something. So this was the case that gave us judicial review, really helped lay out the powers that the different branches of government have relative to each other. And that's the significant part of this case. McCulloch versus Maryland was our big federalism case. Okay, this is the case that established, this is a case about the banks between the states and federal government. Does the state of Maryland have the right, does the federal government have the right to charter a bank? And does the state of Maryland have the right to tax that bank? Now, this is the case that helped define for us what the necessary and proper clause was. So, necessary and proper clause basically says that the federal government does have the right to charter a bank because it is necessary and proper to carry out other things that they have the right to do, such as print money, things like that, collect taxes, and that the states do not have the power to tax the federal government, because the power to tax is the power to destroy. So that if you're taxing basically up, federal government, even though we have co-equal branches of or co-equal types of government between federal and state, federal government ultimately can impose things on the states can't impose on the federal government. So this established that necessary and proper clause and really kind of helped articulate the relationship between the state and federal government. Okay. Schenck v. U.S. was a case from 1919. This was the case that gave us that clear and present danger test. So is my speech constitutionally protected if my speech causes harm? So if you remember this case, this was our kind of one of our post-World War I cases that looked very closely at this issue of freedom of speech. So we'd had the Gitlow case shortly before this. This case had to do with the Espionage Act that Congress had passed. We had implemented the draft in the country. Schenck was standing on the corner distributing leaflets telling people to resist the draft. And the reason why the court struck this down and said it was unconstitutional is that if you are interfering with the U.S. military, that can harm the country in some way. So your speech is imposing a clear and present danger to the United States. Therefore, that speech is not constitutionally protected. Now, this case was expanded on later on. We talked about the Brandenburg versus Ohio case, which basically dealt with the KKK, which said their hate speech wasn't a clear and present danger because it wasn't specific. If a person says, let's go attack this person right now, that's not going to be protected. But if you broadly talk about a group of people, then the court has ruled that that is protected free speech. So this helped kind of define what free speech is in this country. So it talked about clear and present danger. All right, Brown v. Board, obviously we've talked a ton about this case, so you should know this case by now. So Brown v. Board is the case that's going to desegregate public schools. This was the case out of Topeka, Kansas, and it's going to overturn Plessy versus Ferguson. So Plessy versus Ferguson established separate but equal. Brown versus Board is going to use that Dahl test to say that any sort of separate facilities are inherently unequal. You can't have two separate facilities that are and say that they're equal. Baker versus Carr, this is the first of our gerrymandering cases or redistricting cases. This was the case out of Tennessee. Tennessee had basically not changed the number of seats they had in Congress for 60 years. So because of that, they hadn't redistricted their lines in 60 years. So basically what was happening is that they were keeping their districts exactly the same from one census to the next because the total number of seats they got in Congress hadn't changed. Now, what happened over time is that as people moved around the state, you ended up with some districts that were significantly larger than other districts. And we had a lawsuit. And what this case really established was that the Supreme Court does have the ability to step in and to issue a decision in these cases. Now, this was a 1961 case. This was during the Warren Court. So this was a very liberal court, which is much more likely to kind of push kind of pro-federal agenda, or in some cases liberal agendas. And basically what they're going to say here is that, first of all, you have to make sure that you redistrict after every census, as people may move around the state. And it establishes this principle, together with the case of Reynolds v. Sims, which is not one of the required cases, established the idea of one man, one vote. So my vote has to count the same as your vote. So if we're living in different districts, we need to be living in districts that are of roughly the same population so that our votes are essentially the same as each other, even though we're living in different places. So this is going to establish that principle of one man, one vote. A year later, we get the case of Engel versus Vitale. This was our case about school prayer. So Engel versus Vitale was when they would open the school day at the school with the Pledge of Allegiance, and they would follow that up with a prayer that opened with the words "Almighty God." And a student brought suit and said that this shouldn't be something I should be subjected to at a public school, and the court agreed. They said that even though this was a non-denominational prayer, it wasn't specific to any particular god or religion, the fact that a school was mandating that students participate was unconstitutional. So again, remember kind of the rule of thumb between adults versus children, and this is going to be key because one of the sections that is on the AP test is the civil rights and civil liberties section. So you need to make sure you can distinguish the difference between adults and children, is that adults can be subjected to religion. City council meetings open with prayers. School board meetings have been known to have religious officials offer a prayer. If a student is a captive audience, though, we treat it differently. So this is going to be one of the things that Engel versus Vitale once again reiterates, is that students cannot be forced to hear a prayer if they're in kind of a captive audience that they can't leave, which obviously school would be that situation. Next case from 1963, so a year later, and these are all Warren Court cases we're going through here, was Gideon versus Wainwright. Gideon versus Wainwright was the case out of Florida where the guy allegedly broke into the pool hall in Florida. He was denied the right to an attorney because it wasn't a death penalty case. And in the state of Florida, you were not entitled to an attorney unless you could face the death penalty for the crime that you committed. Gideon gets sentenced to 5 years in prison for breaking into this pool hall. He writes the letter to the Supreme Court. The Supreme Court agrees to hear his case. They give him a lawyer. They kick the case back down to the lower courts. He's retried with an attorney, and he wins, so he goes free. So remember some of the terms we talked about with that. The act of the Supreme Court hearing your case when you can't afford it is called in forma pauperis. That is a Latin phrase basically called a pauper's brief, someone who can't afford a case. If the court believes that you have a legitimate argument, the court will oftentimes agree to allow your case to be heard either for free or by assigning you someone to hear your case on your behalf. So that's what happened in the Gideon case. So Gideon versus Wainwright was one of our selective incorporation cases. It's going to apply to the states this idea that you're required to have a lawyer if you are charged with a crime. So this case is going to lead into the Miranda v. Arizona case, which obviously you should probably know for the AP test. You'll see here it's not one of the required 15. But Miranda v. Arizona, obviously a significant case as it relates to rights of the accused. And that's something that falls under civil rights and civil liberties as well that you could be asked about. Tinker versus Des Moines, 1969. This was right at the tail end of the Warren Court, right as we moved into the Burger Court, which was right after that. This was our black armbands case, having to do with the Vietnam War. These students wore the black armbands in protest of in support of the truce that had been called during the Vietnam War. The school basically told them if they wore the black armbands to school that they would be subject to suspension. 3 of the students arrived at school with the black armbands on. They were met at the door by administration and they were suspended. They brought suit saying that they were denied their right to freedom of expression. The court agreed and said that the school had violated their constitutional rights. Now, the big thing you need to know about Tinker versus Des Moines is this idea of prior restraint. So prior restraint is the idea of punishing someone for an action before they basically do anything wrong. So they didn't know that these armbands were going to cause a distraction during the school day. They just made the assumption that they were going to, and they punished the students before they had actually done anything wrong. So the idea behind Tinker versus Des Moines is this idea of prior restraint. Now, prior restraint also carries over into the next case on here, which is New York Times versus United States. And this was the case we just had a couple chapters ago while we were on distance learning, having to do with the Pentagon Papers. So this was the case. Now remember, this is not New York Times versus Sullivan. New York Times versus Sullivan was the case with Martin Luther King in Montgomery, Alabama. This is a different case. This is the Pentagon Papers case, in which the court basically ruled that the New York Times does have the right to publish under freedom of the press. So this was a situation where the New York Times had published the first chapter of the Pentagon Papers and is planning to publish additional chapters. The Nixon administration tried to step in and tell them that they couldn't publish the rest of the document. They tried to issue an executive order, and the court said no. You have to allow them the chance to publish. If they do violate something, if they do publish something that's of national security issue and you want to go after them after the fact, that's fine. You can do that, but you cannot preemptively punish someone for actions if you don't know if they're going to do anything wrong. And you definitely can't restrict the press in this country from being able to exercise freedom of the press. So this was the case that really kind of reiterated how the freedom of the press issue in the United States. This was New York Times v. U.S. That was 1971. Now, 1972 was a case that we did not specifically mention in class, but we talked about the concept. So this would be the one, if you didn't come to any of the review sessions, I went over this in detail at the review sessions, but if you didn't come to any of those while we were still at school, this is the case you want to make sure that you write down. Wisconsin versus Yoder has to do with Amish school children and not having to go to school after 8th grade. So we talked about the fact that under religion, freedom of religion, that certain groups can be treated differently than others if their religion specifies certain things. So if you look at the practice of animal sacrifice, there's some religions in which who sacrifice animals, and the courts have ruled that if the animals that they're sacrificing are animals that are used for food, then that sacrifice is okay, even if it's something that's kind of outside the realm of a law within a town or something like that. Well, Wisconsin versus Yoder dealt with a case in which an Amish family did not want to send their child to school past 8th grade. The law in the state basically said a child had to attend school until they were 18 or until they had graduated. And the court ruled in this case that a parent's right to freedom of religion outweighs the state's interest in educating children. So basically, the state cannot force you to go to school if your religion says something different. Now, this case is kind of seen today as the onus for private school education and education outside, particularly religious education, in which a state cannot force children to go to a public school. They have to offer them a public school education, but they cannot force students to go to a public school at all. If you choose to go someplace else. Now, they can force you to go to school, whether that be homeschooled, where parents have to document that a child's being homeschooled, or in a private school or private school setting. But you are required to go to school unless your religion says otherwise, and that's what was established in the Wisconsin versus Yoder case. So that case is obviously very important. Roe v. Wade, we talked a lot about earlier this year. This was our abortion case. Big thing to know here is this established the trimester system. It kind of walked the line between federal and state power. So in the first trimester, mothers are guaranteed the right to an abortion with no government interference. In the second trimester, a state can ban abortions, but has to still allow abortions if the health of the mother is in question. In the third trimester, states can and oftentimes do ban abortions entirely. So those are the three parts of Roe v. Wade. Kind of connecting that to modern context today in terms of, we talked about the heartbeat bill that Ohio had passed, knowing full well that violated Roe v. Wade, because we tried to ban fetal abortions when a fetal heartbeat can be detected, which was in the first trimester. And the point of that bill that was passed by Ohio was to challenge Roe v. Wade in court. Now, obviously, with the coronavirus stuff, things in the Supreme Court have been put on hold, like everything going on in society right now. So that hasn't really moved really beyond where it was before. But that's kind of the idea there. But that is, Roe v. Wade is still the law of the land today. We had a couple cases that tried to backtrack on it a little bit. We talked about Planned Parenthood v. Casey, which said the state can put some restrictions in to make it harder for a woman to have an abortion, but they ultimately could not deny an abortion if it was in the first trimester or if it was in the second trimester and the health of the mother was at risk. Okay, so that was key in Roe v. Wade. Shaw v. Reno was our second of our gerrymandering cases, and this dealt with racial gerrymandering. So Shaw v. Reno, this was a much later case back in 1993, which basically said that gerrymandering is okay. Okay, drawing congressional lines to benefit one political party is fine. However, racial gerrymandering, drawing congressional lines to benefit one race or ethnicity, is not okay. So if you're manipulating lines to screw over Democrats, that's one thing. If you're manipulating lines to screw over minority voters, that's something different. Okay, and the court struck down racial gerrymandering in this case. Now, we've kind of bounced back and forth on this. Now, the thing that really served as the background for Shaw v. Reno and why this bill or why this case was ruled the way it did was the Civil Rights Act of 1964 and the Voting Rights Act of 1965. Now, again, those are key documents, particularly since civil rights and civil liberties is one of the 3 units on this test, and Martin Luther King Jr.'s Birmingham jail letter is one of the required documents. That could very easily be your argumentative essay. So having to do something with that, so this would be a case for you to pull in Shaw v. Reno into that discussion, chance for you to pull in the Civil Rights Act, Voting Rights Act. You did that assignment earlier this year on the Civil Rights Act, so you should have written out those provisions of the Civil Rights Act. You might want to have that handy when you go in to take your test as well. Again, strongly recommend those things there. U.S. v. Lopez was our guns in school zones case. So this was our case out of Chicago, where we had, I'm sorry, not out of Chicago, San Antonio, where they had, the federal government had passed what was known as the Gun-Free School Zones Act, which basically banned the possession of a handgun in a school zone or anywhere near a school. Lopez was caught with a gun on school grounds. He challenged this federal law, saying that the federal government doesn't have the right to issue this law, is that this should be a state power under police powers. And Lopez won. Now, this was the first, and the reason why this case is significant is that this is the first case that kind of walked back and started pushing powers back to the states. Everything before this had been federal power, growing federal power, particularly under the Warren Court, giving the federal government more responsibilities. This was the first case that kind of took a step back and now said, okay, now we're going to let the states have a little bit more power in terms of the things that they get to decide. So, big idea here is that state powers over police power issues, so health, safety, and welfare, override the federal government's power, particularly as it relates to the Gun-Free School Zones Act. Citizens United versus FEC 2010 case. This was our big case having to do with campaign finance. So remember, we had the 5 parts of the McCain-Feingold Act. So McCain-Feingold was the campaign finance legislation that was passed in the 2000s. McCain-Feingold goes into place in 2003. Immediately after it was passed, Mitch McConnell, the Senate Majority Leader, he wasn't Senate Majority Leader at that time, but he challenged that ruling in court. They challenged McCain-Feingold in court, and the court in 2003 completely upheld McCain-Feingold, 100%. Now in 2010, when the court changed a little bit, and they're going to get this case stemming from the Hillary Clinton movie. So Citizens United was a conservative nonprofit group. They ran a Hillary Clinton video, or they wanted to run a Hillary Clinton video prior to the 2008 primaries when Hillary Clinton was running against Barack Obama in the Democratic primary. Their video was said to violate the McCain-Feingold Act because it was run within 60 days of an election and it didn't specify who paid for it. Now, if you remember, those 5 parts of McCain-Feingold, they put limits on hard money given directly to candidates. They put limits on soft money that's given to political parties. They said that campaign ads had to say who paid for it. Okay, and they put limits on when ads could be run. If it was within 60 days of an election, the ad could only be run by a candidate. It could not be run by any outside group. And the 5th provision was that it banned ads that were run by businesses or interest groups in entirety. So this was not a business or an interest group. This was a nonprofit organization. So technically they could run an ad, but they weren't a group that first of all, their ad didn't say who paid for it, and second of all, they were a non-candidate trying to run an ad within 60 days of an election. So if it was before 60 days, this group probably could have got away with it, but when they were trying to run it, they couldn't technically at that time. So Citizens United takes their case to the Supreme Court. By the time it gets to the court, it's long past the election date, so we've kind of, all of that has sailed. The court struck down 2 of those provisions. So they struck down the provision on the time frame. Anybody can run an ad whenever. If my speech is free today, it's also going to be free tomorrow. You can't make restrictions there. And they also struck down the part about businesses and interest groups not being able to run ads. They basically said that basically money is speech. And if businesses want to spend their money on a candidate, they have the right to do that. If interest groups want to spend their money on a candidate, they have the right to do that, particularly through political action committees. And we'll review political action committees on Wednesday of this week. A final case here is in McDonald versus Chicago. This was our gun case out of Chicago, where the city of Chicago, to try to curb gun violence within the state, tried to pass a law that banned handguns in the state of Chicago. McDonald, who was a hunter who owned a shotgun, filed suit against the city of Chicago, and he's going to win. And he's going to win, saying that this is a violation of the Second Amendment. What this is going to do is it's going to extend the Second Amendment to the states, and say that states also cannot pass laws that restrict the right to bear arms. Now, D.C. v. Heller was the earlier case that had to do with this. This was the trigger lock case that came out of Washington, D.C. We mentioned before that the reason that D.C. v. Heller didn't extend the Second Amendment to the states was only because Washington, D.C. wasn't a state. So otherwise it would have also have extended to the states. Okay, so those are your 15. Those are the required cases. What you can see here is that even though they're not going to ask about these cases directly, I think you could very easily work one of these cases into the second piece of evidence that you're going to need for that argumentative essay. So even if they don't ask about them directly, I think you have a lot of opportunities here, and this is going to demonstrate to the College Board and the people grading your test that you understand the required stuff for this class, even though they cut that question for this, that you understand it anyway. That's going to help you and make your score a lot better. Okay, so these are the required cases. Tomorrow we will start walking through Unit 1. Please make sure that you send me a picture today of your screen of you taking that practice test. That is required from everybody by midnight tonight. If you have any questions or having any problems, please let me know. I'm not sure when they're going to send that email out. I'm hoping it's fairly early this morning so that you already have it. If you don't have it, if you're looking at this video early in the morning, you don't have it yet, you may want to wait a couple hours, check back. But if you're having issues, if you don't have it by 11 or 12 a.m. or 11 a.m. or noon, please let me know, and I will see what we can do about that. Okay, hope you all have a good day, and I will talk to you tomorrow.